Hello, my name is Kurt Young, and for the last 3 decades, I've been an attorney who's fought for Ohio's working families. For me, a big part of my job is to explain the legal system to people like you, and that's why we're making these videos. Today, I want to talk to you about wage loss. This is a benefit for folks who can't get back to all the duties of their old job because of an injury and are losing money because of it. Whether it's temporary or permanent, if you're not earning what you used to due to your injury, this one's for you. Now, let's get a few things straight up front. To get wage loss, it has to be based on inability to work due to the allowed medical conditions and psychological conditions on your workers' compensation claim. And the amount you're paid, well, that's not what you'd be getting paid now. It's based on something called your average weekly wage, or AWW. And if you don't know what that is, well, you need a lawyer. To get wage loss, again, you have to have medical restrictions. And I'm sorry, they got to be from a doctor. We are really insulting to nurse practitioners and physician's assistants in the system unnecessarily. And they need to be on the right form, and they need to be tied to the allowed conditions, and they need to be updated regularly. What do I mean by regularly? Well, temporary restrictions are only good for up to 90 days. Permanent ones, only 180 days. I had a doctor call me yelling one time, "Mr. Young, do you think the arm grew back?" And I said, "No, doc, but we got to have this form every 6 months, so help us out." Unless your wage loss is with the same employer you were injured at, you'll need to register at ohiomeansjobs.com for job search assistance. Now, there are two fundamental kinds of wage loss in Ohio workers' comp, working and non-working. Let's start with the one they like, working wage loss. Why they like it is it's easiest to document. Best case, you're still working for the same employer, and you're making less than an average week from the year before you got hurt. You get the doctor's restrictions in the right form, show your job and the pay stubs, and boom, it gets paid. Working for a different employer, well, now you have to prove your old employer didn't have any work for you and that your new gig isn't a dream job for you. I actually had a case where the other side argued my client gave up a $100,000 a year job for a car manufacturer to put in watch batteries at the jewelry counter at Walmart because she always wanted to do that. Yeah, that wasn't bought by the hearing officer, but now you get this benefit only for 200 weeks maximum on your claim. After that, well, you're on your own. Tough news, especially if you're under 55 or 60 and now find yourself in the less paying job. Now, the trick most attorneys don't know, even who do workers' comp, is there's a special kind of working wage loss if you're losing pay due to treatment. Even if you don't have restrictions, if the only time you can get your treatment is during work hours and you need it to keep working, you can get the difference between the average weekly wage and what you got that week. You absolutely need me to get that one. So what if you're not working at that point? Well, if your maximum medical improvement, the temporary totals end, so now you have to do something called non-working wage loss. This is when you're really going to have fun. Your new job is looking for a new job, full-time, unless your job was part-time or your doctor gave you restrictions, but those are going to be challenged down the road as far as hours. Document everything. I had a client during COVID who didn't have a printer, and the Bureau needed us to fax it to him, so we had to print it out and then fax it to him, and it was a good 1.5 feet thick. I'm not kidding you. It was huge. They argued it wasn't enough. I'm happy to say the hearing officer said that was absolutely enough. Worse is how long you can get this. You can only get this 26 weeks unless the economy is in absolute free fall. If we're at Great Recession or COVID recession levels of unemployment in Ohio, you can borrow 26 weeks of the working and make it a total of 52. But after that, you're on your own. How do they figure out what's due? Well, it's all paid on that one based on average weekly wage. You get 2/3 of it. Don't know what that is? Again, see, you need a lawyer. So now you know the basics of wage loss in Ohio workers' compensation. Thank you for watching. By the way, just a reminder, I am only licensed in Ohio, and each state's laws are different. The system is highly technical, and this is not legal advice or even everything you need to know. Unless you've met with me and signed a fee agreement and other necessary Ohio workers' compensation forms, I'm not your lawyer, and I can take no actions to protect your rights. Nor can I warn you about every deadline to act or a requirement, and missing out on ones, even the ones you don't know about, can cost you all of your rights. So the answer is yes, you need a lawyer to give you and your doctor's advice and look out for you. If you're in Ohio and want our help, call our office, 419-244-7885. If you want more information, go to our website, www.kmylaw.com. Please also like this video, share it, subscribe to our YouTube channel so you get more of these. Thanks, and see you next time.